And there's a coffee for you if you want.
Oh,
Coffee is
okay.
like on me.
what link this time?
Maybe what's on.
Oh. So, thank you very much. And thank you very much for coming again. We had first contact already years ago when the PNR issue was coming to the table the first time. And it was very interesting for me the way you presented your knowledge and the interesting facts around PNR. We are rightly now coming from a meeting on the PNR issue concerning the opinion in the Transport Committee, where, and this is very strange for an opinion, we got 200 amendments. Normally for an opinion you get about 15 or something like that. This shows the high interest of people in the issue. It is always touching upon fundamental questions like first on the base, the illusion or the imagination that you could catch terrorists and seriously you could prevent serious crime by collecting data of all people flying. And how to work it out and to set it in practice in this highly competitive and fast world is a challenge. And we, of course, have within the Parliament a very heavy debate on that. If it comes to which data to collect, how to proceed, and so on and so on. And I'm very happy that you are here as, I think, one of the best experts on PNR issues and with your own experience, which you told me, so that I think you can give us a good input first and then have a little bit questions and answer rounds, because I think you could help us a lot of in presenting a good position which could, if we are lucky, get some majorities. I don't know how the Libre Committee is right now working on, but in the Transport Committee, of course, it's also the concerns of airlines, travel agencies, and so on that play a role, and the cost factor. Please, Mr. Hasbrouck.
Thank you, Eva Lichtenberger. Very much appreciate the invitation and the opportunity.
Can you use the microphone?
Do people need that? It's better? Okay. Sometimes I'm loud enough. Some people think I'm too loud. And I apologize if my English is too fast, too complicated. Please, somebody wave at me. I have a lot to try to cover. This has been much of my life, has been these technical questions. I think this is a very important opportunity because, let me say, I am here as a technical expert. I spent 15 years working in the travel industry with airline reservations, with PNRs at every level. I've also more recently have the practical experience of testing what happens when I've asked for my PNRs, both from the US government, which I'm now pursuing in a federal legal case in the United States, as well as with European Airlines, which I'm currently pursuing with the North Rhine-Westphalia Data Protection Commission against Lufthansa. So I wanted to try to ground this in reality, because I think there is a problem that the PNR debate has been based on some mistaken assumptions about the underlying infrastructure, and it has been disconnected from some other important discussions, for example, about cloud computing, of which PNR data is an important precedent and example. So I want to talk a little bit about the particulars of these proposed PNR agreements, especially the one with the US, since I'm from the US. I want to talk about my lawsuit against the US Department of Homeland Security, because many of the statements made in that lawsuit by the US government contradict the statements that they've made here in Brussels to you. I want to talk about the way PNR are used to make no-fly decisions and that implications on human rights, which have not previously been considered in the debate here. And I want to talk about PNR data in the global cloud of computerized reservation systems, because the issue of PNR has been talked about mainly in terms of the US government's access, but this is a problem worldwide, both with governments and commercially. So, I also want to bring a little perspective for the Parliament from the United States. I know it's new for you to be talking about parliamentary approval of an international agreement. We have 200 years of experience. It's written into our Constitution that the Senate must advise and give consent to international treaties. I think there is unnecessary time pressure being felt to come to a quick decision about the PNR agreements. But the experience in the US is that there is nothing that the US Senate approaches more cautiously, more slowly, and more carefully than whether to give approval to an international treaty. It is very hard to undo such a decision, and it's very important for all the questions to be answered. Over the years in the United States, more than 100 treaties have been signed by the President, but never approved by the Senate. 20-some have been actually rejected by vote, and another 80, more than 80, have never been put to a vote because the questions of the Senate were never satisfied. They simply allowed them not to be ratified. And in other cases, it's been as much as 15 years, sometimes longer, after a treaty was signed by the President before the questions of the Senate were answered satisfactorily and they were willing to ratify it 4 presidential administrations later. So I think you should feel no haste. Take care in what you are doing here. When you look at the proposed agreement as it stands, I was in Strasbourg last April when the Parliament debated and voted on terms of reference and conditions for ratification. It's important to look back at that resolution and see whether those conditions have been met. They have not. And I think it's important to understand what those conditions actually mean. Can't see it. All right. Too weak to see. Here we are. Okay, first, it's not a treaty. What that means is it will not be ratified by the U.S. Senate. It has no legal standing in the U.S. It cannot be invoked in any U.S. court. It cannot be enforced through any procedure within the United States. So if you want to look at enforcement, you're going to have to find some other mechanism. And in practice, there's no way that you can, other than through U.S. courts, enforce what the U.S. government does within its country, which means the agreement is unenforceable and meaningless. Second, and again, these were Parliament's own, your own conditions that were not met. Second, Parliament said very properly that the terms of reference for the agreement must include not just rights of data protection, but the fundamental rights to freedom of movement, which I will come back to in a minute, as defined in the International Covenant on Civil and Political Rights. Parliament said the agreement should not include data mining, should not allow data mining, but there's nothing about that in what came back. Parliament, and this I think very particularly addresses Frau Lichtenberger's concerns, Parliament drew attention to the issue of PNR data that could bypass the agreement because it's already in the US with the database hosting providers. Again, this loophole has not been closed in the proposed agreement. And finally, there is no independent review or judicial oversight. And again, I think my own legal case shows the problems that faces even for a US citizen. Now, in trying to sell and lobby here for this agreement, and to promote it in the United States, the US Department of Homeland Security has said that they apply fair information practices, that there is auditing and accountability, that they allow access, that they allow redress. These are their promises. These were repeated earlier this month before the US Congress. But when I actually asked for my PNR data from the Department of Homeland Security, now none of you could do this because the US Privacy Act only applies to US citizens. But when I asked, first, they did nothing for 3 years. 3 years after I made my request, well, I filed a lawsuit when they had not answered. In response to my lawsuit, the official position in court is first that nobody has any right to see their PNR data because 3 years after I made my request and just before I filed the lawsuit, they made a new regulation exempting PNR data from the Privacy Act, even for US citizens. But they also said that even if, and so we are arguing in court about that retroactive exemption, they also said that even if, so I should say, even if I am successful in this lawsuit, I will be the only person who ever gets to see their PNR, because any new request is exempt even from a US citizen. But they also said, even if you get to see your PNR, how we retrieve it is secret. Whether we can retrieve it by your phone number, your credit card number, that's a secret. Which other agencies or third parties receive my data is a secret. I can't see that. And even if it were not a secret, we don't know. They have told you that all access, they've said this in their reports, that all access is logged, but when I asked for the logs in my case, they said there are no logs of who has accessed your PNR data. Similarly, the US Attorney General came to the Libe Committee last month, perhaps some of you were there, and testified that there are no examples of breach of privacy, no problems, so any problems are hypothetical. Let us look at some real problems. These are not just about privacy. It's not merely that government looked at the data. They used the data to close the doors of the airplane, to turn the airplane around in the middle of the Atlantic, not to allow people to travel. That is the implication. Now, they will say every sovereign country has an absolute right to determine its borders. That is not correct. Every EU member state, as well as the United States, is a party to the International Covenant on Civil and Political Rights. Article 12 of that treaty, ratified by the US, and cited by the Parliament last year as the terms of reference for or what should be the terms of reference for this agreement, has been interpreted in detail. I really encourage you to look at that interpretive note from the UN Human Rights Committee. Here's what it says. You have a right to move around within the country, you have a right to leave any country, and you have a right to return to your country. And if a rule, a regulation, a law implicates these rights, it must be shown to be necessary. That means that necessary means actually effective, and that there is no less restrictive alternative. There has been no such showing. And this proposed agreement is a clear violation of US obligations, as well as the obligations of EU members under the ICCPR Article 12. So, how is this being violated in practice, in decisions made on the basis of PNR? It's a long series. Fernando Calvo Espino, journalist for Le Monde Diplomatique, again, plane diverted in mid-flight because it was going to pass, it wasn't even going to the US, it was going to pass over the US because he was on the no-fly list. On the basis of his PNR, that's how they found out that he was there. Paul-Émile Dupré, a Belgian citizen here, his flight, again, turned around, diverted in midair en route to Mexico. And you need to understand that when Homeland Security comes here and says, we have successfully used PNR, we have prevented terrorists from traveling, they are pointing to Monsieur Dupré's case as a success of PNR, even though he has been accused of no crime, convicted of no crime, has no recourse in court. But they are counting that in the column of success of PNR, rather than in the column of violations of his human rights, his rights under treaties to which all of these countries are party. It's not limited to Foreign citizens, even US citizens, have been denied their right to return to the country. 2 teenagers, Jabir Ismail, a US citizen visiting family in Pakistan, placed on the no-fly list while he was outside the country. When he tried to return home to the only country where he holds a passport, the United States, where he was born, when he tried to get on the plane, the airline sent the PNR data to the government. The government said, you can't let this man come back to his country. Similarly, a few years later, in the most horrible case, Ghulet Mohammed, again, a US-born American citizen, a teenager, visiting family in Yemen. The US thinks there's no legitimate reason to go to Yemen, so if you visit Yemen, you must be a terrorist. So they put him on the no-fly list. He was, at that time, he'd gone on to Kuwait. His visa in Kuwait expired. He couldn't come home. He was detained for immigration violation in Kuwait. The Kuwaitis tried to deport him to the US, and the US would not let him on the plane on a direct flight from Kuwait back to the US as a US citizen. So he remained being tortured in that immigration prison in Kuwait. The day before he got a lawyer in the United States, the day before his case was to be heard before a federal judge, he was allowed to come home to prevent this from being reviewed by a US court. No no-fly decision has yet been reviewed by any US court. And this is being expanded to flights between other countries. Canada is now enforcing the US no-fly list based on PNR for data to Canadian flights. A whole series of events there. And now we hear that DHS advisors are making no-fly recommendations on flights here in Europe. So, here are some real questions that I think should be answered before you even consider voting to approve this agreement. How many people have actually been prevented from traveling? How many of them were reviewed by the courts? Actually, the answer is 0. Is there any procedure for review of these orders based on PNR data? The answer is no. And then, break down those statistics. How many of those people that Attorney General Holder talked about here in Brussels last month, who were kept off flights, are innocent people, like Monsieur Dupré, and whose rights were violated? And how many, if any, were actually convicted of some legal violation, much less a terrorist offense? The reality is that the statistics they have cited as to the success of this program are statistics as to exactly how many people's rights have been violated. But it's important also to understand why the US wants this agreement. This is the statement at this hearing last month in the US Congress. It was just a propaganda hearing because Congress will not have to approve this as an executive agreement and not a treaty. But the testimony of the Department of Homeland Security by Mary Ellen Callahan, who I think some of you may have met when she's been here lobbying, from the Department of Homeland Security. Why do they want this agreement? To protect U.S. industry partners from unreasonable lawsuits. They do not need or want this agreement to fight terrorism because the data is already in the U.S. They already have access to it with or without the agreement. The only reason for this agreement is as an immunity agreement, to grant immunity from enforcement action here in Europe from travel companies, both American and European, that are already violating European law. That is the purpose of this agreement, and they've admitted it before the US Congress. Now, there's been a lot of focus. This is the diagram of how the process works, and it's very complicated. I think the key thing here is that there's both a portion of this diagram over on the right-hand side that goes on within the Department of Homeland Security, but there's also a bidirectional connection to the airline's reservation systems. And I want to focus a little attention here on what goes on the other side of that diagram, because there's been a lot of attention to the copies of part of the PNR data that the government makes, and not on the master copies that exist already in the commercial sphere. Anytime you put data into a global cloud, meaning there are multiple copies in multiple countries, there's a risk. Every node in that network where the data is copied or can be accessed is a point of vulnerability. That's a vulnerability for the individual if the data leaks out, whether to governments or to criminals. It's also a financial and a legal risk for travel companies, which can't control or protect the data they put in that cloud. And it's that risk, it's only that financial risk that's going to prompt these companies to fix the problem. This agreement is intended to remove that so that they won't bother to ever fix the problems that have existed for a long time in this sector. You know, we've been talking about transfers. The agreement talks about transfers from an airline in Europe on the right side to the US Department of Homeland Security. Sounds great, but that's not the way it works. Almost every airline outsources hosting of their database to one of a small number of companies, most of them in the US, Computerized Reservation Systems. These are database hostings and cloud services providers for PNR data. So in reality, the travel agent or the tour operator or the individual is connecting to, in the case of the one CRS in Europe, Amadeus, it's Amadeus that's storing the data and it's accessed from there, whether by the airline or by DHS. That still makes it look like the data is here in Europe, and it's the access by DHS that is the breach of that firewall. But that's not really true either, because Amadeus has offices in the US, in Miami, just as it does around the world. And so DHS can go to the Amadeus office in Miami with a national security letter, which does not require a judge's approval. They can order them to retrieve the PNR, any PNR, not just for flights to the US. They can order them to turn that over to the government, and they can order them not to tell Amadeus, not to tell the airline, not to tell the tour operator, and not to tell the passenger. We have no idea how often this already happens in the US or any other country. Okay? Now, it's also the case, I said this is a cloud service, there are multiple copies of a PNR. For example, if the travel agency uses one CRS and the airline uses another, each of them has a copy in different places. So if your travel agency uses Sabre, even if you're making a booking on Lufthansa for a flight from Berlin to Vienna, the first copy is made in Dallas, in the Sabre system, and only then transmitted back to Amadeus in Germany, where their data center is. This data is already in the US, even often when you're flying within Europe. And it's not just Sabre, but also WorldSpan and Galileo, again, both based in the US. And it's not just Homeland Security, but other US police, the FBI, hackers, criminals, again. Every point in this network is a point of vulnerability. And so what we have is other countries as well that don't even have to go through the airline, the CRS in Europe. They can get it from the US or these other countries. And of course the airline, the CRS have offices around the world where there may be no controls. The key thing here is that the CRSs themselves have never implemented any geographic limits on access. Now, you might say this is reasonable. Maybe you're traveling in China, but next week you're going to be traveling from Berlin to Vienna. And you call the Lufthansa office in Beijing to say, can you give me the information about my flight next week from Berlin to Vienna? They need to be able to retrieve it. But there's no limit. Anyone in that office can call up that PNR, and no record is kept of that. So, are they calling it up in Beijing because you called the Beijing office or came to the counter in Beijing and asked about that flight? Or are they calling up your reservation in Beijing because the Public Security Bureau of China came to that office and said, call up that reservation for Frau Lichtenberger next week from Berlin to Vienna and tell me about it? Because there is no control, no restriction on the purpose, and no law, unless I am looking over the shoulder of that person in the office in Beijing when it happens, unless we're caught in the act, after the fact, there's no record. Lufthansa doesn't know that it happened. They can't, if you ask did it happen, the honest answer is we don't know. Amadeus keeps no record. And you have no way to know whether any country you might name, China, Israel, Saudi Arabia, Nigeria, Colombia, or of course other rogue states like the US, might have accessed your data. Either for criminals there who have bribed the office to give them the information, or the government, the local police who came there. So this is the problem. And because the data is already spread this way, any agreement about a particular pathway to a particular government is essentially meaningless, because there are so many other pathways by which they can get this data. Now, as I said, each PNR has a change log, but they do not keep a log of access. Technically, it would be quite straightforward to do this. It would involve some expense. They should have done it when the Data Protection Directive was adopted 20 years ago, but they waited. Why spend money if there's no enforcement? And they waited, and there's been no enforcement, so they felt no need to change. I know this because I've specifically requested from KLM, from Air France, from Lufthansa, can you tell me to what countries my data has been transferred? And none of them has been able to tell me. None of them. Because they don't know. They honestly don't know. I've complained, but it's very difficult for the data protection authorities. They're very reluctant to take action against their national airlines. I still do have a complaint pending in Germany. But they, I think, are not feeling that pressure. And also, the airlines, really, even if they mean well, they can't do much about it, because the problem is in the broken, illegal infrastructure of the CRSs that have failed to properly control these transborder transfers. And I think this is a crucial issue for the TRAN committee, to look at how to bring commercial transborder transfers of PNR data into compliance with the EU Data Protection Directive. For those who don't already know, and most of you have never seen your PNR, because I'm going to show you a little bit about what's in it. Of course, your name, your address, your mobile phone number, your passport number, your credit card number, everything an identity thief wants. Your IP address, very commonly, so they can correlate it with data retention of your internet browsing history. Where you go, who you go there with. I have seen all of this is transferred to DHS. Not just in the PNR. I have seen in a PNR obtained from DHS, most people who've requested it have gotten at least some part of their data, although censored and incomplete. But I've seen in that for two people who traveled together, who made a hotel reservation in the same PNR with their flights, for those two people, and we know their name and their gender and their age, their date of birth, their details, behind the closed doors of their hotel room, did they ask for one bed or two? That is in their permanent file with DHS. Here's one of my PNRs. Part of the problem, as you can see here, here is, you can see down here, that's my IP address that I made that booking from. Part of the problem is that this is very cryptic, so most people, even if they get some part of their PNR, they don't understand what it means. So this is a problem. But we also see PNRs already for flights within Europe, not just in the DHS system. This is a very interesting itinerary. This person flew on United Airlines from San Francisco via Frankfurt to Berlin, okay? And here we have a United flight number on a flight operated by Lufthansa, so we know with that code share that even though that's a Frankfurt to Berlin flight, every PNR for that flight is copied in the United system in the United States. We also have, and then they returned eventually from London to San Francisco. Now these were flights from the US, or at least connecting and back. But in the middle, they flew on Czech Airways, that's okay, from Berlin to Prague, and Prague to London. Flights on a European airline, within Europe, not connecting to any flight to the US, and we know from the rest of the PNR that these were a separate ticket. But DHS had the entire itinerary, including the flights within Europe, in their file for this person. Now, even if United Airlines looked at this, the US airline that supposedly turned over this PNR for the flights to the US, United Airlines could not see that flight on a competing airline with a separate ticket. What this means is that DHS actually has route access to the CRS, because that's the only way they would get these flights. They already have the ability and are using it to retrieve data about intra-European flights, separately ticketed, not connecting to flights to the US.
But only if it is connected with a flight from the US.
I have been shown by a source at the Amadeus data center in Erding records that were kept for debugging purposes, transient records. They don't preserve these logs, but some temporary tracking from monitoring access from the addresses registered to DHS, retrieving flights completely separately from flights that did not touch the US.
Okay.
That may have stopped now, we don't know, because there's no real possibility of auditing. So if you go to Cuba, maybe the US knows and they give you economic sanctions the next time you go to the US. This is a street in Sana'a. You know, maybe you go to Yemen and next time it's you who goes on the no-fly list or ends up being tortured in Kuwait or wherever. They also attach remarks. The travel agent, the airline can all put remarks about you got angry at the person in the call center or at the counter, and those go through in your permanent file. The inspector at the airport can attach files. So this is from my own file. Passenger verbally declared food, one apple was seized, bread was inspected and released. It was left from the buffet at the hotel for breakfast in London. No civil penalty assessed. Nothing illegal here. But it goes in my permanent file that they took my apple. Passenger arrived from Argentina, visited a livestock show. His shoes were cleaned and disinfected for possible decontamination. Now there's something very biblical that the border guards are down on their feet at 6 o'clock in the morning in Miami washing my shoes. But why is this in my permanent file? I did nothing illegal. This is now a basis for action. This is another person I know. Passenger attended computer conference in Berlin and then traveled around Europe to visit friends. 100% baggage exam. Nothing was found. Passenger is a self-employed entrepreneur in computer software business. We better make a note of that for his permanent file, very suspicious person. And so this is now part of the basis for these secret decisions in the future about whether to let him on the plane. Passenger has many small flashlights with pictures, little things like this with pictures of marijuana leaves. Pictures, not marijuana. He had a book entitled Drugs and Your Rights. So the title of the book he had that he was reading, if you read about your rights, you must be suspicious. This is the kind of data that is being used. This is the kind of data that DHS says it needs to fight terrorism, and that is the kind of person they are using it against, Monsieur Dupré. So I think we need to broaden the PNR polemic from privacy and data protection to human rights, including in particular the freedom of movement under the International Covenant on Civil and Political Rights. And I think Article 12 of the ICCPR is something that should be of paramount importance for the Transportation Committee, obviously. We need to broaden it from how the PNRs are stored and the data protection question to how they are used to prevent people from flying. We need to broaden this discussion from US use of the data to global use of the PNR, from government use to government and commercial use, and from the DHS copies of some of this data to the master copies that are scattered throughout the world in the cloud. Clearly, I think the Parliament itself, in its resolution last April, already gave the grounds for which this proposed agreement with the US should be rejected. They should not follow this bad example and start doing these same bad things or do them more by adopting the proposed EU PNR directive. Not generalize it to other sectors through a framework agreement on data transfers that would legalize this sort of thing in other sectors than transport. Ask travel companies for your PNR data. This is something that goes beyond what Parliament can do. It's individual complaints that may help force national data protection authorities to enforce the existing law 20 years late. And finally, PNR data needs to become a key example that is considered. When you talk about cloud computing, realize that it is not new. PNR data is the canonical example of intimate personal data that has been stored in a global cloud for years. And so if about the two. In practice, they're mostly stored in the same systems. It's much more convenient for the airlines that way anyway.
Edward, the difference is that AP data are covered by a sort of international agreement by the ICAO. So it's an obligation is given to a public authority. PNR data are private data used for public purposes. The legal framework is different.
Yeah, that's the point.
Well, I think the most important part of your question, Emilio, is your reference to ICAO. And I think this is also an important issue. And maybe this gets to the answer, Eva, to your question originally, because it's related. I mean, in terms of what can be done to fix this, one thing that can be done is to put access logs. The PNR already has a change log. They know how to do that. It is technically quite straightforward to use the same methodology that every time someone changes the PNR, it's recorded with the user ID and what change they made and when they did it, so it can be audited later and so it can be reported to the subject. The same methodology could easily be used so that every time a person looks at the PNR from a travel agency, the airline, whatever, that access is logged in the PNR in the same way. That is technically very straightforward and doable. So that would not solve the problem, but it would make it possible to detect and audit and enforce the problem. Yeah. So, but you also referred to ICAO, and in particular, the proposed EU PNR directive would require compliance with whatever standards ICAO adopts in this area. It would delegate to ICAO the power to set the future PNR system, even for use within Europe. And that makes it very, very important for the TRAN Committee in particular to inquire into exactly what is going on with ICAO. The Commission holds an observer seat at the Machine Readable Travel Document Group, working group in ICAO, and helps appoint technical experts to its working groups. I don't think Parliament has adequately inquired. I think you should call before you in the TRAN Committee the Commission participants in the ICAO meetings and talk to them about whether the terms of reference for their representation of the EU at ICAO include the right to freedom of movement, include civil liberties, include data protection. In practice, national delegations to ICAO consist of police and border guards. They have never included national data protection authorities. And I believe that it's important both for the EU and for individual members to make sure that their national data protection authorities are not merely consulted, but are included in the delegations, particularly to the Machine Readable Travel Document Working Group, which is the one that handles the PNR and API standards. Because otherwise there's no voice when ICAO is setting the standards for any concern for fundamental rights. One only hears in those meetings from the police, and the technical experts are only technical experts in policing, not experts in fundamental rights. And that is a problem that I think can be fixed by action, both by this Parliament and within your members, member states, in relation to their national delegations to ICAO.
Please.
Thank you so much for your presentation. In relation, there was a slide at some point, and you mentioned that Parliament should reject, I quote, the data framework agreement. Could you further elaborate on that? Just because, in my head, that would be the umbrella agreement which is currently being negotiated between the EU, and that would apply inter alia to PNR, TFTP, and so on.
Perhaps Ralph should speak to that, if you care to what that is on behalf of Jan Albrecht as rapporteur.
Abandoning the agreement, of course, so you have to elaborate on that.
Well, basically, the US has made clear that it is unwilling to have that framework agreement be a treaty. So it will have the same defect, since it cannot, as an executive agreement, it can't give anyone any rights in the US. So unless it's a treaty, all it can do is take away rights here in Europe.
may be naive, but I think that even an executive agreement impose a sort of loyal cooperation rules, which requires that the public administration on the two sides of the Atlantic should more or less follow what they have agreed, even if this do not impinge on a particular fundamental rights, but it's a way to treat in particular framed way some data. But I agree with you, it's not a treaty like the treaty were ratified by the US Senate, so you cannot change the US state, but you can frame the way how the administration works. And this will be something that you can challenge if there is a violation of good faith principle.
I think perhaps, unfortunately, you are too trusting of the US government. In the US, neither businesses nor government obey the law because someone says it's the law. They obey the law because a court makes them obey the law. And without sanctions, I don't think you can expect that there will actually be any compliance.
Please.
I mean, we have this code of conduct for CRS in Europe. Do you think that the CRS actually violating this code of conduct, or is there a need to change this code of conduct?
I did submit comments on behalf of the Identity Project with which I work when the Code of Conduct was last under revision, and there were some small changes, some small improvements to the data protection provisions of it. But yes, it is being violated. It places controls on access and transfer, that the reality that any office of the airline or CRS anywhere in the world can retrieve any of their PNRs is in violation. So every time any travel agency stores their PNRs in this cloud, they are violating the agreement. An airline or a travel agency that wanted to comply would find it impossible given the current CRS infrastructure.
Yes.
This is your duty, because it's the Transport Committee to control the Commission, to control the CRS on EU territory.
From another point of view, looking at the technology, comparing them, the CRS cloud, its node technology is 40, maybe even older, based on mainframe systems, text-based, free text, flat files, and probably very smart and efficient at the time. But two things here. When I've talked about this in different contexts, where you have the conflict between civil liberties and law enforcement, it kind of gets stuck. But then when I say, like, I think both parties here will have a different situation when Google or some other new technology platform enters into the travel industry, because they will probably create new databases with new architecture where access logs will be part of the solution from the start. And comparing with Google, they have some projects, transparency projects, whatever you think of Google, but they are moving forcefully and using privacy argumentation as a safe point, where they log all requests from law enforcement authorities over the world and report when they have given data and when they have not handed over data. So that's with new technology there are options, new options to fix infrastructure issues. And then thinking of the API subset of the PNR, to me it sounds like that is at the time when storage and processing of data was expensive. I used to work in the mainframe system 10 years ago, and there were still old guys there that optimized disk space and very complicated. But nowadays, I mean, you have terabytes of data for less than 100 euros. So storage is not a cost anymore, and processing, you can do whatever. I would say that the text-based systems now, they can probably run on legacy software with speeds that are exceeding what they could ever dream of when these systems were constructed. So I think it sounds to me that the API subset is some kind of compromise when at the time it was expensive to store and expensive to process data, that the CRSs agreed to hand over a particular, to build the system for that particular cost to hand over data to the authorities. But now that framework and the technology is meaningless, or it's just an old-fashioned way of looking at it. Even if it's another framework, but I think that framework is related to the legal framework is related to that particular technology parenthesis or part of the history. So we will move into the cloud, and new technology will be there, and whether or not it will provide freedom and privacy at the same time as commercially valuable services, that's where we are, also with the PNR discussion. This was not a question, but maybe...
No, if I may, I think you make a very good point, and I think this is why it's important to fix this problem now before we move forward and build new systems on a broken foundation. Because the new technology creates possibilities to make things better or to make things worse. On the one hand, as you say, Google last year spent about $750,000 US to acquire ITA Software, now a division of Google, which is the first company trying to build a new CRS on a modern platform. It'd be interesting to ask them what they plan to do about these questions and how they will address them. But at the same time, it used to be that airlines would throw this data away because they could, as soon as possible, so that because they couldn't afford to store it. But now they are developing increasingly sophisticated data mining. Amadeus itself, not long ago, acquired the largest PNR data mining company, which, although it is a division of Amadeus and thus governed by EU law, operates in flagrant violation of the law as a PNR data mining company active in the US, where it already was, that analyzes and mines data from PNRs from all of the CRSs. So the technological improvement can go in either direction. We need to be setting policies now to make sure that it goes in the right direction and gets a good foundation.
But this is my question, is it not already too late to it? Because if we see, that's the point, because how to hands it in again? If we see that Homeland Securities and so on already have access to raw data and they use it regularly, this is something that we cannot block because we don't have access to US lawmaking. That's one point. The second point is, if it comes to the access logs, this is implied when we ask for feasible redress for persons that are asking for their PNR data. The point is, we do not have so many cases of people that have been asking for their PNRs, so that they always refer we do not know about because we never have been confronted with the question. So I think the problem is less the lawmaking, but the point that nobody understands deciding on these whole issues, that the problem of the access logs is behind the request for redress. But if the redress is not done by persons, physical persons, and requested then their data and so on, nobody will really make the investment, because of course this would mean a technical change within the CRSs. And I think this is the point where we mostly have to go to, already at the point where data is collected before it gets passed or before it enters into the computer system, must be already reduced at maximum. Because if not, you can't call it back anymore. So this is my impression. If I listen to you, I try to find out where would be some points where we can get a agreement on having an initiative. That's a little bit as you described. As you described the situation, I do not see too many possibilities of fencing the whole thing in.
I think.
To that,
Yeah, okay.
as a follow-up to Eva.
Yeah. So please, Ralf.
Yeah. It's really related to what you asked. As far as I understand you, Edward, what we should do as to fix the underlying problem is to fix the reservation systems on the technological level, to in a way ensure that people can only access my reservation data if I agree to it, or something like that. It reminds me of what happened with SWIFT, the bank data system 2 years ago, when they changed their architecture so that the bank transfers that are not related to the US are not stored in the US. And that later on led to the new agreement with the US and the EU. But then the question is, how do we make the reservation system owners change the technology? Is that a problem of data protection law enforcement? So is it already, is our European data protection law good enough? We just need to enforce it and we need more people to go to court and stuff like that to make more fuss about it? Or is that something we should fix in the upcoming review of the Data Protection Directive, for example, because there's already a big debate on what to do with cloud computing and so on. Or before all of this is done, some people say, like for example, I won't mention names here, some people say that before we have the fundamental fix, we still should do an agreement with the US, a PNR agreement and a data protection agreement, to at least have a preliminary cover or protection of some sort. So where do you fix and when and in which order?
If you agree, we will first hear the answer and then go to you.
I think one of our experiences in the US is the importance of transparency as a first step, as a vehicle toward exposing problems so that they can be fixed. And so, for example, a Privacy Act that gives a right of access to dossiers about you, or a Freedom of Information Act so you can see government documents, doesn't fix the problems. But once people see that the dossiers are being kept, or once they see what government is doing, then they can address them. So this is why I think that the access logging and the right of access to them is a first step, so that at least people can know what is happening, so that there's a record of it and they can know what is happening. As far as the second step, I think this is where Eric's comments and the role of technology companies like Google that are bringing new approaches to this need to be tapped to set a better example of somebody looking at this fresh, who does have this kind of data protection as one of the basic criteria for their architecture development. This I think is, it's a multi-stage process, but I think we have to start. Now. It's late, as Eva said, but I don't think it's too late, and I don't think we should just say this is so bad and it's gone on so long that we just give up.
Where is the point?
Anyway, yeah.
It was more answering if, in my case, it is the application of PNR or not. I think yes, because it was just the two cases, Calvo, the Colombian journalist, and myself 6 months after. It was just after the provisional application of PNR, on one side, and also the airplane was not going to the US, it was going to Mexico. So the airplane, because of the application of PNR, what they explained me on board is that they sent the data of who is in the airplane flying over the US to the US, and during the flight the US answered, and I think that is application of PNR procedure. No? Sorry?
Not PNR. Exactly. Because everything says who is on the plane, because it is people who made the checking.
But how could can you explain that? Just 2 months after the provisional application of PNR,
No, but
the US those airplanes are delayed.
to be frank, they told me that it was not because of PNR, but because Mexico sent the RPA data to the US.
Well, the company, they were very borrowed. Immediately they said me, they sent. The airplane sent the details,
The
the list because they are obliged, because of the new implementation, because of the.
Because of it.
No, I think that they are doing that now because.
Because you was on the flight. So
Yes.
you was a real passenger.
Yeah.
Not like in PNR where you can be a virtual passenger because the flight is not yet there. So your name was there, and the name has been sent to the destination country.
But Air France said me that it was a new procedure. They were not doing that before, the year before.
I don't want to defend the Commission. The Commission told me
No.
that it was
No, the problem is that the Commission is defending the
Just to intervene, this was the rule that was agreed on, because there was a big debate in which time limit the data of the passengers has to be sent, and the AP data are more or less a subset of the PNR data. So anyway, the question is, where did they get it from? And technically, as far as I understand the process, it must have been out of the CRSs, but it has maybe been only the API data set. Basta. But it is, it might most probably have been running over this CRS machine. If not, it would be absurd. There was no extra registration of people because it was processed on the flight. But anyway, I think this is not this is not the central question. It is API data, but API data is of course underlying a general agreement worldwide. So this will not be changed. Everything that's in the API cannot be refused to be processed to begin with. But anything else is what is now in debate. I think you wanted to say something. Yeah.
I would like to get some more information on what they exactly, who they is in the first place, and what they exactly do with the data. Because apparently they have some blacklists of people who are not allowed to fly, like our colleague here.
No fly list.
No fly lists. How do you get on these fly lists in the first place? Is that because they already know you and think you have some affiliation to some terrorist groups or whatever? Or is that because of some data mining or profiling approach? Because you just have some criteria that match some kind of probability that you might know terrorists? And what else do they do with the data? It's not really clear.
Well, this diagram is what they say they do with it. But we don't really know. I mean, fundamentally, what happens is that this is all a black box. And what happens is the data is pulled out of the CRS, it goes through, this says DHS router, and it sends it in several directions. This is a whole analysis unit, including DHS and other departments in the US government. And then these are connections to other external databases, commercial databases. But ultimately, this is all secret. There is no law, there is no regulation, there are no standards, no court ever reviews this. Somebody, we don't know who, sits in a secret room somewhere and looks at whatever information they have and pushes a button, yes or no. And in reality, they can't think about everyone, so there is some profiling algorithm Again, this is part of the issue in my court case, is I specifically requested the algorithm. You are also entitled to that under European data protection law. The rules used for automated processing, Lufthansa has refused to tell me the rules used by DHS for automated processing of my Lufthansa reservation. That is a violation of their duty under EU data protection law. So they won't say the algorithm, but there's some robot that uses some secret algorithm to decide which PNRs get looked at by the human being. But
whatever.
Someone in the secret room somewhere who decides to push the yes or no button.
Yeah.
You say the yes or no means board or not board, fly, no fly.
Yeah.
But for example, we have had some discussions with the UK representatives here because they also have some kind of PNR surveillance monitoring system in Manchester for flights in and out of the UK. And they say they don't use it for fly, no fly decisions, but they mainly use it for matching patterns, for finding suspects, so to speak. For example, if people come to the UK, accompany of a child, and then they fly back alone. It might be child human trafficking or something like that, or they look for people who regularly come from, I don't know, Colombia and only stay for a few days and then fly back. They might be drug smugglers. So it's not no fly, no fly, it's for finding suspicious people.
And that is something different, of course.
Yeah, and this is the lack of purpose limitation in the U.S. process. And so there are other purposes, again, we don't know. And this is the problem with the sharing, passing on to other third parties, other government agencies, governments in other countries. We know that the U.S. is sharing this data with other countries. We don't know which one because U.S. law does not require them to say. And it's a little bit more subtle than just fly, no fly. There's a third position in the middle, which is let them fly, but search them and scrutinize them more carefully, inspect them more closely. So there is a middle position in the decision making.
Yes.
I would say, in the future, if many countries apply that, all planes will travel. I don't know, but if Israel retakes the PNR list of the US and applies it, so how it will be possible to travel, to go from here to China, something like that. And the other thing, in my case, I ignore completely why I was in this list. I am a leftist militant, so like the land protest, etc. But now we think that it was because it was a request of Colombia, because we had here an action of the MEPs against Uribe in the plenary, and I was coordinating for MEPs in my normal work. And now there is a legal case in Colombia, and those people were attacking human rights defenders in Colombia and outside are now in jail in Colombia. But I remain the list. That's the situation. They are in jail with a definitive decision of the Supreme Court. It's quite an exception in Colombia. And it was the head of the department, the police department of Uribe. So it was a decision just 1 more month ago. So most probably because of the dates when I began to have problems with migration in the US, that was just 6 months after his action here in Strasbourg. So that's probably there were a close link between Uribe and Bush in that time, and we think that it was they consulted probably in Colombia. Well, this guy he has in an address book some. My wife is Colombian, for example. He has some telephone number, etc. Probably they said, yeah, it must be linked to the FARC, something like that, because they know me for human rights.
Okay.
As a parliament, we are dealing, as you know, since 2003 with this issue.
Yes.
One of the big solutions which was offered to us was the idea to have a sort of a broker, CETA, which is a company which currently filters the data for Australia, for Canada, and were available to do the same work for US or any other country requesting PNR data. Let's also frame the exercise. These data are required for security purposes. So the real issue at stake is the proportionality of the measure,
Right.
and is the margin of appreciation of a government which will be respected by any judge, because the judge should respect the right of a government to protect the security in his own country, but should be framed by law. The point that we are here working in a domain where law are different, the way the margin of appreciation is measured are different. So you can have the US approach, which make a wide use of intelligence-led police exercise, and the European Union, which is just starting to do more or less the same exercise.
Yeah.
So as a legislator, the problem is how to frame, how to define the proportionality of the measure to be taken, how to build a system who are privacy compliant at the beginning, and probably because of the evolution of this domain, maybe the current generation is not fitting with these standards, but the future could be fitting with our standard if we start asking for them now.
Yeah.
If not, in 10 years we will continue to work on the previous one.
Yeah. If I may add to that, this is of course one of the points. Proportionality is, of course, it has been also a very important point in the whole issue of the body scanners. And it has been a major issue in the whole issue of SWIFT and so on and so on. So this is always the question, but this is more or less let's say, a question of decision making. I watch in the Transport Committee that some members coming of certain member states like Spain or Great Britain will justify everything with security. So if the security, and this is a little bit like in the US, if the security, as long as the security question is on the table, everything else has to step back. That's my impression about not about what I think, but what majorities think. So what we found in the debate was that especially some member states, and these are those who had been living with terrorism for a long time, like Great Britain with the IRA and Spain with the ETA, are much more willing to ignore questions of proportionality and uselessness or something like that when it comes to data. As, for example, states like Germany and Austria and some of the Eastern new member states that have seen recently what a government can do with data as soon as they have them in a complex way, there's more sensitivity. So the German court decisions on the data retention, for example, has been very enlightening in that sense, that really says, okay, there is an historic experience behind, on the one hand, being more in favor of privacy issue, more in favor of control of the use of data, and on the other hand of the threat of terrorism that justifies everything. This is what constitutes the debates and the defining of majorities. My point would be, if it comes to proportionality, and we, of course, cannot be certain how the outcome of within the majorities would be, that if people do not make requests for their data, if people do not follow up on their PNR, it's easy for everybody to justify. So whatever we might decide as a regulation, if it is not requested by the people being objects of that rules, it's a question of access logs. We had that already in 2006 or 5 when we were deciding, I'm sorry, when we were deciding on the CRSs, because this was also an issue in this code of conduct thing. They said, okay, of course we will grant every possibility to redress, but nobody tried it out, obviously. Or those that tried it out didn't make it public, what was the result of it. And I think this is one of the crucial problems that we have right now in the debate. Because if you explain to transport committee members that it is without an access log you cannot even correct your data or get to know who has accessed and so on, they don't believe you. They think we have to trust them, that they will obey the law. That's the problem that we are facing. Eric was.
I think the mentioning of CETA, as far as I understand, it's a company set up for solving the problem for the CRSs to hand over data. So it is in this particular time of technological development where the cost for the companies to hand over the particular subset of data was too high to, or it needed to be standardized in some way. Maybe Altiero was involved, or IATA was involved in that. But CETA is this particular intermediary that's pulls in stuff and delivers as a company. And I want to add to this discussion also what I've seen from the airline organization, IATA, the commercial airlines, where they had the yearly meeting, last in Singapore, I think, where the chairman was telling all these 400 CEOs from airlines from all over the world how great their organization was and how much money they had saved and their progress for biofuels and serving customers. And then in the middle, he said, but we have one problem, and that are the CRSs. And then he showed a picture of a business profile, a guy with suit and tie in profile, and from his neck was hanging 4 leeches with blood dripping. As a picture in front of this chairman, and the logos of the CRSs were on the leeches. So it was Sabre, Amadeus, WorldSpan, and so forth companies. So the CRSs are viewed from the airlines, commercial airlines, as blood suckers. And this is where maybe the commercial perspective is for. There is maybe a business need for new technology to step in here, because if the airlines are depending on an infrastructure that is pictured as sucking blood from the industry.
Yeah, but these are 2 different pair of shoes, because the airlines do not want to carry the cost for it. That's very simple. If the business is done by someone else and paid by someone else, they couldn't care less.
Yeah.
That's the problem.
I can tell a little story. I was at an ICAO meeting in Montreal a few years ago, and the vice president of IATA, their chief lobbyist, spoke in front of, this was a meeting of the ICAO Machine Readable Travel Documents group, and the representative of ICAO spoke and said, governments, we're not your enemy as airlines. We're your friend. We ask only 2 things. We will collect whatever data you want, we'll deliver it however you want, as long as you bear the costs, and we get to keep the data afterwards and use it for our own purposes. That's all we ask of you.
Right.
Very straightforward.
Yeah.
I want to go back to the question that was raised about CETA as an intermediary. The problem is having
CETA or filtering somebody else. It's only about filtering this one direct connection to DHS. And it doesn't, even if you break that link entirely, much less you filter out certain data, as long as all these other pathways exist, DHS, the US government, other governments can still get the data. So it's a bit meaningless there. I mean, CETA was established, it's a cooperative jointly owned by the airlines, so it's a way that the airlines can jointly fund shared technology development, basically. But it really doesn't solve this problem. And in terms of proportionality, I think the proportionality decision should not be being made by people in the secret room. It's one thing to look and see, is this a person who there is a warrant for their arrest from a court? But I think it should be explicit in the agreement that the only basis for a no-fly decision should be a court order. Do we have procedures for injunctions? I'm sure you do in your member states. It's fine to have a list. You have a list of people. There are procedures through Interpol for and in Europe for international warrants. If a court has ruled that Monsieur Dupré is such a danger that he should not be allowed to fly, then that can be distributed to all the airlines and they can stop him from flying. But no justification has been given whatsoever for moving the fly, no-fly decision-making process entirely out of the courts. So I think to tie the no-fly order directly to a court order on a judicial basis is crucial to inserting the principle of proportionality into this system.
But we do not deal with the no-fly decision here. That's in the PNR issue. This is not included. What is the result of a possible data mining or profiling or whatsoever is not touched upon by this directive. This is a little bit of a problem. We cannot go to that because this is, of course, a different juridical system. So it might be difficult to touch upon. But the point is, for me, much more interesting is how to solve the problem more on the source. Your proposals, please.
I have to say once again, the absolute necessity as the minimum starting point is rigid, non-repudiatable logging of all access to the PNR at the root in the CRS. And secondly, compliance by the CRSs and the airlines, the other travel companies, through whatever, you're Europeans. It's for you to decide what the best mechanisms for enforcing your existing rules. I'm telling you, you know, they are not being enforced, they are not being complied with. So to comply with the rules regarding access, so that we can at least know the problem. And then, if the problem is people are not asking, everybody I know who has asked for their PNR, who's gotten any portion of it, and has been able to sit down with myself or someone else technically knowledgeable and see this is their dossier and this is the information in it. Everyone has found something that they did not know was there, that they did not want to be there, that they did not think belonged in a permanent file with the government. So I think we will see more public concern that will drive the political process once people are more aware of what's happening.
So you're talking to the wrong people here. You should not talk to legislators, but to data protection authorities, right?
Yeah.
Oh, what's the point?
Well, the code of conduct for CRSs is enforced directly by the Commission. So again, I think the question for the TRAN committee is to talk to the Commission about what are they actually doing to audit whether the CRSs are complying with the directive. And do they have in place a process for complaints of violations of the directive? I don't believe that they actually do. Once that is made public and they say, this is the point of conduct, this is how, if you believe that an airline or a CRS is violating this, this is what you can do to complain, then they might begin to receive those complaints. And that's something that, again, can be addressed here.
There was another aspect that we already had when we were discussing the code of conduct for the CRSs. This was the whole issue of the use of the data for economic purposes. So, because this was one of the heaviest debates that we had, because certainly the Parliament wanted to limit the use much more than they would agree on. But for me, the most interesting point is that this, of course, is the first actually existing clouds that is now coming into debate. And it will, of course, in the creation of new clouds, give us enormously difficult legal questions. So if we can again step a little bit over the PNR issue and deal with the cloud issue, because we had in the legal committee also an opinion on what should be considered when it comes to cloud computing. What would you say, what could be, technically speaking, the only feasible and enforceable, difficult questions, isn't it? Feasible and enforceable infrastructures that we have to create if we have to deal with all the incoming legal questions concerning cloud computing, including there, of course, and mainly also the economic use of data. Because this will be one of the major issues in the debate.
You know, this is really a much larger question, of
Yeah.
course, and I think there'll be many perspectives here. But I think some of what we've been talking, access logs, I think, you know, in general, if you're storing data in the cloud, you need to know where it is, you need to know who's accessed it. And the problem is the CRS cloud was devised for the benefit of its users. And its users are the travel companies, not the consumers, the individuals, the public. And this is much the same, I think, for many of the other commercial cloud services, that the public is not considered the user. So there are rules about one travel agency accessing reservations from another travel agency to protect them against their competitors, but not to protect the public in the architecture of the system. The other problem I think that the CRS and the PNR example exposes for cloud computing is the question of jurisdiction. Because we've seen a false debate about PNR for European airlines or PNR for flights to Europe. But jurisdiction is based on where the data is collected. You can go to the American Airlines office here in Brussels and make a reservation for a flight from New York to Los Angeles. That is a reservation clearly for which American Airlines, although it's a US airline and it's a flight in the US, if they want to do business here in Brussels, they have to respect Belgian law with respect to that reservation. But they make no attempt to do so. They just say, that's a reservation for a domestic flight in the US, so they don't even think about European data protection. So what's needed is to tag the data in some way. Again, it goes back to logging. Tag the data so that for different pieces of the PNR you can identify where that data was collected. You can't tell now from the PNR where different portions of the data were collected. And a PNR is not created all at once. Information as you check in bags, that's added to the PNR. You reconfirm your flight, more information is added to it. Information at different times is added very often in different countries subject to different jurisdictions. But there's nothing in the record that would even enable them to tell what jurisdiction they're supposed to follow. So either they have to track that jurisdictional information for each part of the PNR or the Google Doc or whatever it is, and respect that, or they have to apply the highest standard in any country or jurisdiction where they want to do business. Those are the choices that they should have with a cloud service. And if they don't want to and think it's too expensive, I don't think it is. Data storage is cheap. Logs are cheap, they're easy. But if they don't want to track the jurisdiction applicable to that data, then they must be obliged to follow the highest standard for all of that data.
Okay. That's a heavy thing. So, is there any more questions? If not, I would thank you so much for your input. I think it has been very helpful. Also, especially, the Transport Committee has only the opinion on the whole issue. In the last period, we had the whole dossier, especially when it came to the CRSs. But for the ongoing process, it will be very important that the right questions must be posed. We can pose the questions concerning transport, because already we had in the debate in the Transport Committee the problem that our Spanish members, British members do not want to have all those data protection issues in. And I think they have to be, because it's not to be separate, it's not separable. It's the airlines that say they do not want to police their clients on the one hand, and so it is interconnected. It's also a business and transport decision. And it is, of course, a decision that affects traveling in the end, if it comes to no-fly results, something like that. I mean, I have the most concerns of the third country partners then, because if we, for example, then enter into a good exchange with China, I will not enter this country anymore, I'm pretty sure, because of the information scheme coming from other states. So we will really have problems on that. And thank you very much, because I think you're one of the very rare experts in this field, that you came again and gave us some input for the debate. Thank you very much for your being here, and I think we will stay connected for the ongoing debate. Thank you.